It's 10:21. During the recess, DER staff provides us, and I provided copies to both attorneys plus our attorney. This is a report that shows that Jonathan Steckner was, with an effective date of February 3rd of this year, 2025, was a rehire as business systems coordinator in the city attorney's department. So we had a reinstatement action by this commission which allowed this to happen, and this report indicates that it did in fact happen effective February 3rd, 2025 to the one IT position in that department. So those are facts for purposes of this hearing.
At that, the Office of City Attorney would move for a directed verdict in this matter.
A directed verdict is where
we make a decision based on the record to date.
Yeah, and it's not been this commission's prerogative to
No,
grant those.
and we, it's not granted.
Fair enough. At this point in time, the Office of City Attorney would rest.
Okay. Okay, so if there are no more witnesses for the department,
Correct.
then we would look to Attorney Hitchcock Cross to call his first witness. But I just want to remind him and all of the people in the room that we have one exhibit that we did not deal with at the initial meeting, and that was the AU one, and there was a specific person who we thought should do that exhibit. That remains outside the record at this time. Just for every
three.
Yeah.
I have it noted at
AU.
AU.
4.
AU.
Do I have it incorrectly?
It's the text document with a series of notes on it.
handwritten
Handwritten
notes,
notes, yeah,
and it's unmarked in
right.
terms of there's no signature of any kind,
I understand.
or even not even initials. So that lies out there, and it's not part of the record unless it becomes one through a witness. With having said that, do you have a witness you'd like to call?
Yes, thank you, Mr. Donahue.
Good morning.
Good morning.
Well, first of all, we will have the witness identify his name and job title, and then we will have the court reporter swear him in.
Sure. Harper Donahue, Director of DER.
Could
Sir,
the
if
court
you could
reporter?
Yes. Sir, if you could raise your right hand, please. In the testimony you're about to give under the pains and penalties of perjury of the state of Wisconsin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Sir, can you hear me?
I can.
Okay. Thank you for testifying here today. I know we've put you out from your usual tasks, so thanks again. You do know Mr. Young, is that right?
I do.
Okay, and how do you know him in a business sense?
In a business sense, he's a city employee, or he was a city employee. I met him through a former DER employee.
Okay. And did he ever come to you at any time in say 2024 about his employment?
Yes.
And about when was that?
I want to say fall, October, September, October, somewhere around there. Maybe November.
I'm going to interrupt here, and because I want to make sure we understand what the parameters are. Mr. Donahue reports or works on behalf of the commission in terms of running the pre-hearing conferences with the attorneys and the appellant and the department head. And I'm concerned as a commissioner about whether he's going to be testifying as to the merits of that case. I don't think that would be appropriate. We have had, I won't call it testimony, but we've had, because it's not sworn testimony, pardon me, from Mr. Donahue and from Ms. Moore about procedural issues, and I'm referring to timeliness or whether or not there was agreement by the parties on the nature of the issue. Whether, in this case, of course, the parties did agree that it would be, they agreed, or pardon me, the commission agreed that it was timely, and the parties agreed that the question is whether it was reasonable under civil service rule. Those are the procedural questions that were, and both of them were taken care of. So I don't know that Mr. Donahue should be testifying about the merits of the case if we're going there. And I understand because of the questions asked of the department representatives already, there's some interest in the issues of the PIP program, and I'm sure that Mr. Donahue and maybe one or more of his senior staff people advise departments about PIP, but that is not really before us either. What's before us is the separation for the reason indicated on the document, which is that he did not have clearance for the computer system. So I don't know that, and our counsel can comment on my approach on this, but I'm not interested in having Mr. Donahue testify on the merits of the case, which is the separation for lack of clearance. That doesn't seem appropriate. I think my looking at the statute, and I don't have it with me right at the moment, but is that he handles the hearings on our behalf, and he's supposed to be a neutral party at those hearings and to help both sides. If he hears something that's favorable or unfavorable to the other party, I don't think we want him testifying to those kinds of things. That isn't his role in the process. I think that's up to the attorneys for the respective parties to advocate for their through witnesses, either departmental witnesses or appellant witnesses. I don't know if Mr. McLean has any comments, but I don't see the role for Mr. Harper Donahue as director, because he did handle the pre-hearing conference, I believe. I don't see a role for him to be testifying on the merits of the case.
I don't think there's any disagreement about that. I don't think we're trying to, I think the only thing that might be helpful, and excuse me for interrupting, or get us to where you want us to be, is just when you say merits, it's my understanding that he sort of has a double role. One as a role, someone that department heads or others can come to for questioning, and then as another as, I guess, your agent, for lack of a better word. My understanding is that we can separate those two things, and I'm just trying to focus on the interactions that he had with the department heads prior to the filing of this Civil Service Commission appeal. So I hope that clarifies that. If you need more, I'm happy to do that. I'm happy to look whatever else, but hopefully we're on the same page with that.
To add to that, I did object on similar grounds, President Bach, during the pre-hearing conference, and thereafter, the director indicated that he would remain a fact witness.
Well, that's his role. He's been
Correct.
delegated that role by the commission.
Correct.
That he, or in his absence, Ms. Urban, who's on the screen, that one of them will conduct the pre-hearing meeting with the parties, and I want them to be able to act independently, and be helpful to both sides, not just to the department, but also to the appellants, many of whom, especially nowadays with the fewer union representatives active, it's more important than ever that Mr. Donahue or Ms. Urban be able to advise the appellants regarding their rights and what they should be bringing forth at a hearing. So that's my concern. And I'm sorry, I can't quote from the statute because I don't have it in front of me. But if you look at the statute as well as the rules, which lay out the responsibilities of the director in relation to these hearings, he or she should be a neutral party and should not be testifying on the merits of the case. And when I say merits, in this case, I'm referring to the separation action for clearance, lack of clearance, pardon me. And in some ways, this case is not about the relatively minor employee issues that might have resulted in a PIP for this employee or other employees, but even that would be on the merits, so to speak, in a sense. But I don't know. That's where I'm at.
Yeah, and the DR director serves as the executive secretary of the board under statute, correct, and the board rules. And to analogize it somewhat, for the purposes of hearings, he performs almost a clerk type role, meeting with the parties, making sure the evidence is organized in accordance with the rules. And I think President Bach's concern is that while there is some degree of testimony that is relevant, like for example, in hearings where we take testimony about timeliness when a certain document was received, that's relevant. President Bach is concerned that this is going to get more into a substantive dispute, which would be appropriate for witnesses called by the department or by the appellant, but not by a representative from the board who was tasked with sort of refereeing those disputes prior to the hearing in a clerk type role. I think it would be helpful can you articulate can you make a proffer of the evidence that you're seeking to elicit so the board can make a
discussions about the list off my client's criminal record, even when you ask them not to. Didn't make any have any problem not stopping them then. They've been able to go into complaints about my client's work performance. They went on for like an hour about that. And we should be able to rebut that. Period, plain and simple. Because they've made the allegations and you've heard them. Beyond that, I think we've also heard testimony from Ms. Shannon, solicited by, again, the department, that she went to Mr. Donahue to discuss PIPs, among other things, and to discuss how to properly terminate my client. And we need to get to the other end of that conversation. So to say that we can't, because he works for you, that we can't hear that is not only tying our hands behind our back. The biggest problem is that that you heard their evidence. And if it was one rule for everybody, that would be one thing. But you allowed them to talk about the PIP, and now we can't talk about the PIP. You allowed them to talk about the conviction record. He can't talk about the conviction record. You allowed them to talk about complaints against.
Well,
we can't do that.
Sir, that's not correct. You'll be able to talk about the conviction record because that's it. That goes to the heart of the matter, either through this witness or perhaps some other witness. I don't know who you might call, but certainly Mr. Young could talk about his own record. And the PIP part is I've tried to shut down both sides as to not going into that, because that isn't, in the end, that isn't where the department head was. I think he testified today that the issue of the clearance or lack of clearance was that preempted any relatively minor issues with PIP that could be addressed perhaps by performance improvement.
But you're proving our point, which is simply this. If you take what the city attorney says as gospel, then yes, there's no reason to cross-examine anybody else or to have any other witnesses, and let's just be done, and you guys can make your decision. But if it's possible that what the city attorney said is not accurate or may be contradicted or otherwise added to by witnesses, which, you know, maybe that's my role here is to display that evidence. I don't know. That's what I thought it was. Then that's okay. But what we've had here is 2 days of character assassination against my client, and we're not even in about 2 questions into what we want to talk about, and it's already questioned if it's proper.
I've been trying to challenge both attorneys that we're not going the PIP route. We're going to be focusing on the reason given on the notice. This commission doesn't deal with other stuff. It deals with what the department, because he has a right. Well, all employees have a right if they're going to be separated or discharged, whichever word you use. They all have a right to know why they're being discharged. And it starts with the letter to the employee telling them of a pre-discharge hearing or a pre-separation hearing, and then it relies upon the separation notice or the discharge notice, and that's where we're going.
The employee has a right, sir, to challenge on whether or not that reason is factually accurate or not. And
Well,
that's
that's
what
true.
we're trying, that is what I
That's-
understand my role to do here today. And so that's why when we get to, as my colleague, Mr. McLean said, a proffer here, the evidence that I'm trying to get from this individual is the conversations that he had with Ms. Shanning and Mr. Goyke about my client. That's what we're trying to get to here.
But if we go into all this PIP stuff, that doesn't go to the merits of the case.
Okay, I'm clear on that. I'm clear on that. I do think I want to be, I mean, I think it's clear that I disagree, but I also think it's clear that we agree that the period between when the PIP supposedly was no longer in consideration and when the CGIS job elimination is relevant though. And I think that's part of what we want to talk about here. Because if they're saying, well, we didn't like his performance, we had all these issues with him, we were going to correct his performance. And then lo and behold, a week later, it turns out we don't have to do the PIP. We don't have to give them any due process. We can just go straight to job elimination. And maybe they discuss that with people. Hey, that's something that we might want to talk about.
I'll let you ask some questions, but I want Mr. Donahue to wait a moment for each question. We're not going to do the PIP business. And we're going to talk about the separation and the basis for the separation. If there was any testimony, if there's any conversation regarding the conviction paperwork, we'll allow that, because that's the heart of this matter.
Okay. And if it just, for example, so happens that, and because we heard testimony on this from Ms. Shannon, if it just so happens that there was pushback from Mr. Donahue on the PIP, can we talk about that?
It's not relevant. I don't want to spend hours and nothing goes quickly with this case. We're not going to spend a lot of time doing the PIP stuff and arguing over each item of PIP. That isn't where the case went.
Well, and I understand, but sir, with respect, we did hear Ms. Shannon go and talk about that she thought it was weird that the password, that she thought it was that she collected complaints about my client, that people had emailed. We heard all about that. That there was.
We heard a small amount about that.
Right, we did.
But and we tried to shut it down as quickly as possible and get the focus back on the case. If you have questions to Mr. Donahue, either about procedural matters, and I've already told the parties on the record, there are no procedural issues. Both the timeliness and the nature of the issue, both of them have been satisfactorily resolved before the hearing. If there are conversations, Mr. Donahue, in regards to the reason for the separation, I'm going to let him ask questions. But if we get off on PIP, we're not going there.
Okay. And I understand. At least for the sake of foundation, can I at least ask him if there was a PIP and was he aware of a PIP? And then I can move on from that?
I'm going to object. This has already been
No,
asked and answered and ruled on.
You don't want to listen to what I told you, and I understand that. You're trying to be an advocate for Mr. Young, but please go to the merits of the case. That's,
I think I can.
and I'm not that comfortable with him testifying even on the merits, as I've already explained to you and to Attorney McLean, but I'm gonna put up with it in this case for the sake of making sure we have a full record here.
Okay, I understand that. So with those parameters in mind, Mr. Donahue, thanks again for coming here today. At some point, did you learn from Mr. Goyke of a issue with Mr. Young's employment?
At some point, did I learn of an issue with his employment?
Yes.
From Mr. Goyke?
Yes.
I may have had a discussion with Mr. Goyke, but I don't think I would have learned that from Mr. Goyke.
Okay. Did you have a discussion on that subject with anybody else at the city attorney's office?
Yes.
Okay. And who was that?
Deputy City Attorney Sharon, possibly.
Okay. Anybody else?
Not that I recall.
Okay. And what was that issue at that time?
When you say an issue with his employment, I guess I'm struggling. Can
I
you
understand.
specifically ask what you're...
Fair enough. And so, I mean, based on the discussion that we just had with the commission, you understand that there was some communication prior to the communication about his possible termination. Is that fair?
Correct.
Okay. So then, but at some point, you talked about with Mr. Goyke and Ms. Shannon about possibly terminating Mr. Young. Is that true?
At some point, there was a discussion about separation.
So, okay. What was that basis? What was the nature of that conversation?
There were meetings with members of my staff.
Okay.
It sounded like there was questions regarding his ability to access CGIS and the necessity to have that access. And there was a discussion regarding the necessity for that access.
Okay. And was that those discussions with your staff only or with you as well?
So there were discussions with my staff prior to me being involved in the discussion. I had discussions with my staff, which led to discussions with Deputy City Attorney Sharon.
Okay. What were the nature of your discussions with your staff?
The necessity to have that access.
Okay. What was your response?
I was questioning whether or not it's pretty much the basis for this meeting here.
Okay.
I was questioning whether or not that was necessary for that position.
Got it. And what was the response of the city attorney at that point?
It felt like they did some homework.
Okay.
They spoke with, I can't recall, but they spoke with a couple folks. I believe they probably checked in some of the regulations and they came back. I think this was in response to an audit that they received, and they came back and felt confident, certain that it was indeed necessary for him to have access to be in that role.
I got it. Okay. And so did you have a follow-up meeting, or when did you learn that there was indeed that they believed it was appropriate?
Probably December, somewhere around December.
Okay. And who did you learn that from?
I believe Deputy City Attorney Sharon was in the meeting.
Okay.
Possibly Robin Patterson
Okay.
was in the meeting. HR Manager Kristen Urban was in the meeting.
Okay.
I believe that there could have been someone else, but I believe that was it.
Okay. And so Mr. Goyke was not at that meeting. Is that fair?
No.
I got it. Okay. And
Not
was
that I
it
recall. It's possible. I believe he was on parental leave. I don't recall him being in that meeting.
fair enough? Okay. And so the purpose of that meeting, if I understood it correctly, was for them to tell you why they, or what homework they had done in regards to the separation of Mr. Young. Is that fair?
It's fair.
Okay. And what reasons did they give you during that meeting?
It was in response to an audit that they received. Again, they spoke with some folks over at MPD, the
Okay.
police department. Yeah.
So that's what they told you, they spoke to MPD?
They spoke with a few folks, like regarding specifically what they did. They felt confident that it was the right decision to make. I don't think it was exhausted to the point that we're going through this hearing, but again, this is 4 or 5 months ago.
I understand. Okay. And so when they say they felt confident, were they explaining, was that a legal position they had or something else, as you understood?
I felt like it was a legal position.
Okay. Now, did Mr. Young's conviction record come up during that meeting at any time?
Possibly.
Okay, and how about conviction discrimination? Did that come up during that meeting anytime?
Possibly.
Okay. And what about conviction discrimination could have come up at that meeting?
I'm going to object to this as a hypothetical. He said possibly, he's not specific.
Well, he said the conviction, I believe he said the conviction record did come up. Is that true?
I say possibly, as far as my recollection, there were discussions that I was involved in regarding his conviction record. I don't recall specifically if it came up in that meeting, but there were questions there were discussions that I was involved in regarding
Conviction record.
Correct.
And you discussed conviction record of Mr. Young conviction record with Ms. Shannon, true?
Possibly. I did have discussions, but I really don't recall if I had those discussions with Ms. Channing or if I had them with my department.
Okay. But you possibly had them at this meeting with Robin Peterson and Mayor Shannon.
Correct.
Okay. And what was possibly the issue about the conviction record at that meeting?
Whether or not that would prevent him from getting access
Okay.
to CJIS.
And how about, was there any issues with discrimination, conviction record discrimination? Did that come up?
I don't recall that coming up
Okay.
within that meeting.
Mhm.
Do you know what Mr. Pedersen's role in that meeting was?
Specifically, no.
Okay. Do you know what he said during that meeting?
Specifically, no.
Okay. How about generally?
I think generally they did some research regarding whatever policies are involved. They reached out to some folks and they felt that they had no choice but to move forward without Mr. Young based on his inability to get access.
Okay. And I don't know everything about your role, but I'm assuming that they weren't asking you in that meeting if they could terminate Mr. Young. Is that fair?
That's fair.
Okay. What was your role in that meeting?
So we have a good working relationship. My role is the director of DER. I like to think that part of that is protecting the city. If we're moving in a certain direction, I just want to make sure that folks are aware of possible consequences, give consideration to different factors. If they felt that it was necessary to move forward without Mr. Young, I just wanted to make sure that they're giving appropriate consideration to what his record was, possibly, or the level of access that he needed, questions regarding his ability or inability to do the job in the past. I just wanted to make sure that they were giving those proper considerations.
Okay, so you don't know if they adequately responded to, for example, the question that you raised about his ability to do the job in the past.
Regarding his ability to get access to do the job without or with having access.
Sure.
I believe that could have been part of the conversation.
Okay, and what was their response, if you recall?
He was in the role, so I don't think it was really a question of whether or not he was doing the job. I think it was whether or not if he was, I think it was more so if it was necessary for him to have that and whatever possible workarounds that they may have had. It could have been along those lines, but I really don't recall the specifics of it.
And did they mention any alternative actions to removal?
No, we didn't discuss any alternative.
Okay, just separation was the only thing on the table at that point?
Based on his inability to get that access, correct.
Okay. And at that point, Mr. Young, when you had this conversation, Mr. Young was still employed, right?
I believe he was on leave,
Okay.
but yes, he was still employed.
And so would it surprise you to learn that Ms. Shanning didn't actually tell the police, the assistant police chief about Mr. Young's conviction record until after Mr. Young was terminated?
I don't know if that would surprise me. I don't know if I don't know the level of detail. I think they were generally speaking regarding what would be required and what would prevent someone from getting access. So
But they told you they spoke to the police, right?
I believe that they did reach out to the police department.
Okay, did they tell you they spoke to the police about Mr. Young?
I felt like they did. And I don't know if they specifically said that or if I was just under that impression.
Okay. And then, so if you were under that impression, would it surprise you to learn that they didn't actually talk to the police about Mr. Young until after?
I'm going to object to asked and answered
Yeah.
in relevance.
That's been handled.
Okay. So, and again, the whole point of that meeting was for them to have done their homework, right?
Or to make sure that they were confident in the necessity to have that access.
Okay. And do you think that it would have been important if you were doing your homework to get this, to make sure that you had this set, would be to talk to the police about Mr. Young's specific record?
Again, I'm going to object to asked and answered.
So I guess part of that.
Just a moment. I'm sorry, I got distracted for a moment. Could you repeat the question, please?
Sure. As part of your, based on your knowledge and experience at the DER role that you hold, do you believe that you would have talked to the police specifically about Mr. Young prior to going to the meeting that you had with Ms. Shannon and Mr. Peterson?
And again, I'm going to object to asked and answered in relevance.
I think he's asking if he, in his role, would be talking to the police department. I don't think that is his role.
No, I'm asking you if you would have done your homework before you would have attended that meeting, and if doing your homework would have included actually asking the police about Mr. Young.
Again, I'm going to object to asked and answered in relevance.
Well, I'm gonna let him answer.
Okay, I think it would have been helpful, but I also think that they deferred to regulations regarding what would have been required and what would prevent someone, and I think that that could have been helpful as well.
Okay, and how about maybe contacting the FBI? Do you think that would have been helpful?
I'm going to object again as relevance.
That's outside the scope of his responsibilities, is to speculate as who they should have been checking with.
I got it, but you understood that the city attorney's office reviewed the CGI's manual, right?
If you know.
So I believe that they looked into it. I think a lot of this was driven off of an audit that they were involved in.
Oh,
So between that and the manual or wherever they were getting their information from.
Right, and they told you, the city attorney told you what they thought the audit required them to do, right?
Yes.
Okay. And you knew that document was drafted by the FBI or something else?
I did not know.
Okay. So Ms. Shannon claimed to interpret that document, the questionnaire, CGI's questionnaire to you during that meeting. Is that fair?
I believe we had a conversation regarding somewhere around there, yes.
Okay. And you believed her because she's an attorney, right?
I'm going to object to leading.
Could you rephrase that?
Sure.
What does he believe?
Did you believe Ms. Shannon, right?
Again, leading.
So specifically the path that they took to arrive at the conclusion that they made, I don't know. I do believe that they arrived at a place where they felt that they couldn't go forward with Mr. Young. I just wanted to make sure that they felt comfortable with that. So part of my role is when I'm talking to the department and making a decision, they don't need my approval. But I do want to make sure that they understand that if we do this, there's a possibility that it could go this way. Are you prepared to have that conversation? I believe that's why we're here today.
I got it. Okay. And did you ever talk to anybody at the city attorney's office about not putting Mr. Young on a PIP at any time?
Again, I'm going to object to this. It's outside the scope of what.
You're going on the PIP route.
Sure. I understand we're not going on the PIP. I thought we had some at least agreement on the period between not having the PIP and the CGIS thing. So I just want to be clear. Was there any communication with you on that? That's the only question I'm asking on that subject.
Again, my objection. And
Yeah, we're not going there,
Okay.
Counselor.
Did you have any conversations with Mr. Young about his employment?
Yes.
Okay, and what was that conversation?
The initial conversation,
Yes.
he showed up at DER. He wanted to meet with me. He had an interaction with a deputy city attorney.
Okay.
Um, about a month prior to him coming to my office.
Who was that city attorney?
Naomi, I'm sorry, I'm spacing Naomi's last name.
Okay. And did you, was there any follow-up with that discussion with Mr. Young?
Yes, I told him that I would reach out to City Attorney Goyke and follow up with him.
And did you do that?
I did.
Okay. And what was the nature of that interaction?
I shared the information that he had an exchange with Naomi. Attorney Goyke was aware of it. From talking to Attorney Goyke, it felt like he addressed the issue. I followed up with Mr. Young. I shared that I did speak with Mr. Goyke. I felt like the issue was addressed. Mr. Young also felt like it was addressed. Mr. Goyke did follow up with Mr. Young about the situation and how he responded to it. And I felt like everyone was on the same page.
And approximately how many days was that before your meeting with Ms. Shannon and Mr. Patterson?
Could have been a couple of months.
Okay. And was that the last time that Mr. Young came to you?
No,
When was was there another time that Mr. Young came?
that he reached out to me regarding his.
Well, I'm sorry, I just want to rephrase the question that he, I guess, came to you with an issue about his employment.
He possibly reached out to me at some point when he had been placed on leave.
Okay.
He may have reached out to me in between that. I don't recall.
And what was, when he reached out to you when he was on leave, what was the nature of that communication?
He felt that he may be terminated. He was asking questions about his ability to appeal.
Okay. I got it. Did he raise any issues with conviction record with you at any time?
He did.
And when was that?
Probably during that time when he was on leave.
Okay. What issues did he raise about his conviction record at that time?
The necessity for him to have access to seizures, his ability to do the job. He shared that he had been doing the job without having access. Just general questions surrounding the importance of the necessity for him to have access.
Between that time and I guess, did you have any other conversations about Mr. Young's conviction record other than that time?
With Mr. Young?
Yes.
Possibly, I don't recall.
Okay. How about anybody else?
My staff.
Okay. And what was the nature of those discussions?
There are questions regarding what happened and the connection between his role, the duties,
Okay.
something along those lines.
And was this prior to his termination?
Probably.
Okay. And what did you respond, if at all?
Well, we had questions that I think that probably triggered the meeting with the attorney's office.
Okay, and maybe I misunderstood that, but so you had conversations with your staff about Mr. Young's conviction record, and then did you go to the city attorney after those conversations?
Or my staff reached out and set up a meeting, I believe. Or maybe I reached out. I don't recall.
Okay, and then so it's fair to say the city attorney didn't come to you first?
The city attorney, they weren't working directly with me. They were working with my staff, and then I was being involved. So a lot of the questions that you're asking, the discussions, I wasn't involved in all of them. I'm not the only person in DER that they spoke with.
Do you know who else they spoke with?
They spoke with Kristen Irvin, staffing manager.
Okay. Anybody else?
Not that I recall.
Okay. When you left the meeting with Mr. Patterson and Ms. Shannon, did you believe that they had done all of the work that they had needed to in order to successfully show to this commission that they had reasonably terminated Mr. Young?
Well, that goes to his opinion of the merits of the case. I don't like.
I'll withdraw the question. I understand what the issue is, and I'll withdraw the question. Was there any other time that you pushed back against the city attorney's office regarding Mr. Young's employment?
I don't think it was necessary for me to push back at any other time regarding his employment. I don't think there were any other concerns regarding his employment. When you say his employment regarding me staying employed,
No, just this terms and conditions of his employment.
I don't think so.
Okay. Did you ever receive any complaints about Mr. Young's performance?
I'm going to object. This is going into performance issues, which I believe his commission has ruled on and said that we're not supposed to get into.
We're here on the access issue, unless you can limit it in some way to that issue.
I just want to know if you've heard it. That's all I'm asking.
Prior to his separation,
Right.
From speaking with Attorney Goyke, I guess I was under the impression that things were actually going pretty well.
Okay.
I think that there was probably a need for clarification regarding expectations, but I wasn't under the impression that his employment, that they were looking to do anything other than make sure that there's clarification.
I got it. Do you know about when that happened?
Again, I think this is going into performance, which this commission's ruled on.
We'll let him answer one more question and we're moving on.
So I believe it was around the same time, shortly after, when I reached out to Attorney Goyke when Mr. Young stopped by my office.
Okay. I thank you for that. Do you know if anybody from your office ever pushed back against the city attorney's office with regards to Mr. Young's
No,
termination?
Again, I'm going to object to this. This has gone through asked and answered now 3 times.
well, I don't know if it has been asked and answered, but I want his testimony limited to the issue before us, which is a separation. Nothing about performance.
Do you know why Robin Peterson was at that meeting?
I believe that he probably brought some type of expertise. I believe he was probably involved in whatever research was done. He's probably more familiar with CJIS and requirements surrounding it.
How did you learn of Mr. Young's conviction record?
It was probably a few years ago.
Okay.
There were questions surrounding him coming to the attorney's office before I came to the city of Milwaukee. Somehow it came back up a few years ago. I don't recall. But I believe I learned it. It came up. It's somehow I don't recall.
Okay.
But I did know a couple years ago.
Can you give us a better sense of a couple of years ago?
Years ago?
Fair enough. I mean, something that
Like it, I really don't recall. I remember meeting him through a former DER employee, and when I was introduced to him, his name did sound familiar because there was some type of discussion regarding his situation.
And this is before Mr. Goyke is the
Correct.
Okay. And do you know who you heard that from?
Yes.
Who?
I believe I had a conversation with Charles Hughes.
Okay. And that's how you learned of the record from?
That was my introduction to Mr. Young.
I'm sorry. Do you know who you learned of the conviction record from?
I don't.
Okay. Would it have been an attorney at the city attorney's office?
No, it would have been a conversation at DER.
Okay. All right. Do you have anything else you think the commission should know?
No.
Thank you for your time.
May I have a brief minute.
Yes.
Thank you for allowing me the brief second to confer. I just have a few questions from the direct. Good morning, Mr. Donahue. Briefly, just wanted to clarify some of your testimony. You indicated that you probably or may have or likely did something. Is it fair to say that you don't remember with any specificity the specific conversation that you had with any member of the management with the Office of City Attorney?
That's very fair.
Okay. Is it also fair to say that this is based upon your remembrance here today? Your memory here today, rather?
Yes.
Not clear as to dates, times, locations?
Yes.
Right. So what you're testifying to is a general thought process, not the specific?
Right.
All right. No further questions.
The commissioners have any questions for Mr. Donahue?
No.
No.
Good. Any further questions?
No, thank you.
Okay. So, Mr. Donahue, thank you. Okay, it's 7 minutes after 11. We're I believe Ms. Moore, I believe that our usual plan is to take a break at noon, and you would interrupt me at 11:45 to remind me that noon is coming up. And with that in mind, I'm going to ask the attorney if he has another witness he'd like to call.
We have another witness we'd like to call. We're trying to arrange for her to get on. Yet I don't know that she's on. We were again expecting Mr. Patterson and Ms. Sanders to testify now. So we are scrambling here, but we will do our best.